So we're going to be interactive here today. Leon County has increasingly become familiar with the fact that there are some air property issues that can actually be resolved if you are aware of the services that are provided by the county and you take advantage of them. DSUM actually manages air property situations. They address them. Today you have some scenarios in front of you, and we're going to go through some exercises that demonstrate the relationship between court action and the role that DSUM plays, okay? So I'm going to start with some definitions. You two can relax.
Okay, all right, thank you.
Air property, actually what is it? Air property is real property for which the holder of the last recorded document is deceased. And that person died intestate, which means without a will. So if that person is the holder of the last recorded instrument, what are those? Deeds, court orders, indentures, those would be the last recorded documents or instruments, and you would be able to find them in the public record. The heirs are those people who own the property immediately upon the death of the person who was the holder of the last recorded document. The holder dies, the heirs immediately become owners. When individuals are owners, then they assume they can do whatever they want with the property because that's what owners do. What we have found is that there are a couple of issues which surface. One is whether or not the heir has the right to dispose of the property, to encumber the property, and to divide the property. What does that mean? Can they mortgage? Can they sell? Can they give it away? The second issue is whether or not they have the right to use the property in the way that they want to use the property. Can they put a structure on it? What size structure? Can they operate a business out of it? So those are two basic. Can you encumber, dispose of the property, and can you use it in the way that you choose to? The scenarios that you have in front of you will help to hopefully focus on what the role is of the legal system, the court action, and the role of DSUM. Okay, now, in terms of court action, these scenarios may suggest that a property needs to be probated, may suggest that the title needs to be quieted, may suggest that the property needs to be partitioned. These scenarios may also suggest that you need to be concerned with contacting DSUM to address zoning issues, to address legal access issues, to address environmental constraints. So for the next 10 minutes and 10 minutes only, either individually or in teams, read through the scenarios, and on the top you see there's a question. It's whether or not the person with the goal will be able to achieve their goal. Yes, they will. No, they won't. The other question is, what issues will the heir face?
All right, again, I'm Ronnie Wright, and I am going to go ahead and read the questions aloud so that everyone can be familiar with them. I know you all have read them, but I'm going to read them aloud as well. Scenario A. So what we're going to do is, will the heirs fulfill their goals, and what issues should the heirs consider to fulfill their goals? Scenario A. In 1885, Fred Fletcher, a banker, purchased a house on Park Avenue in Tallahassee, Florida for $5,000 cash. Fred Fletcher died intestate. Since Mr. Fletcher's death, at least one descendant of Mr. Fletcher has always lived in the house. Goal: the current resident, Frank Fletcher, wants to obtain a loan to rehab the house and use it as commercial property. She already said. What did you say? Somebody already was saying something.
What did she say? Okay. Oh, that was a no. No, he will not. Are there any yeses? Okay, let's walk through this. What is the asset that we're talking about here? What is the asset? A house, perfect. And who is the record title holder? All right, wonderful. The goal is for Frank to secure a loan to rehab this house. Why does Frank think that he has the right to do that? What is in that scenario which makes him think? Because he lives there. All right, this is, wow, wonderful. Now, let's take a look at this. Let's look at it in two different ways. Let's say that Frank, well, let me ask you, does Frank have any other heirs in the scenario? Are there any other heirs? No, there's no information to help you, okay? Now, in terms of what may happen, it is possible that Frank will have other heirs that he discovers. And if he discovers those other heirs, depending on their relationship with Fred, Frank may or may not be in a position to get title and get the loan. But let's just say, for argument's sake, that this is a family where there's only been one child, each generation, one child, one child. So now Frank is really the only heir, all right? And in that case, when he probated the estate, he would move from being an heir, which gives him ownership by operation of law. He would then become a record title holder. What is probate? It's a process by which notice is given to all of the heirs or beneficiaries. The person who is in charge, and there are different names that we use for that person, sometimes executor, sometimes personal representative, that person then makes an inventory, gathers all of the assets. That person also gathers all of the debts, pays the debts with the resources, and what is left then goes to the heirs or the beneficiaries. In this instance, where Fred is the only one, the court would issue an order that would be a recorded document, and Frank would then be the record title holder. One of the things that we want everyone to do anytime they are involved in court action regarding property is to make contact with DSM. In this scenario, it says that Frank wants to have commercial property. Well, he needs to talk to somebody about that. Why? Once the judge issues the order, there's no going back. That's the order. And if there are problems that the now record title holder has that could have been resolved had the record title holder been interacting with DSM, those areas of problem are not going to be resolved, at least not very easily. So in this first scenario, the answer, yes, no, the answer is, it depends. Anytime you talk to an attorney and you're trying to get a set answer and they just won't give you one, it's because it depends, okay? Let's go to number 2.
Also known as Scenario B. In 1920, Geraldine Gomez was the beneficiary of 20 acres in Tallahassee, Florida. Ms. Gomez had 5 children at the time that she inherited the acreage. Geraldine Gomez died in 1925. By 1927, 2 sons had left home and lost contact with the family. Throughout the years, the other children and grandchildren continued to farm the land. Goal: the farming heirs now want to divide the acreage and secure mortgages to build homes.
Okay, what is the asset this time? 20 acres. And the record title holder was? Geraldine Gomez. Why did these individuals think that they should be determined to be the heirs and be able to secure a mortgage? Because they were farming the land. You see how we get these ideas that we're here and we've lived here, it really should be ours. So let's dissect this one. It says that Geraldine is a beneficiary. That means that someone had a last will and testament. She's not an heir, okay? So what Geraldine did not do was to execute a last will and testament. So her children became heirs. I just want you to make that distinction. They farmed the land. Geraldine had 5 children at the time, it says, at the time, but it doesn't tell us how many children she had when she died. There may be more. What we do know is that 2 of those children are gone. When you do a probate action, you really need to know where the people are, their lineage. In this instance, we have people that we can't find. So probate may not be the avenue to take. It may be necessary to quiet the title. When you quiet the title, there is a question about the title. Who are the title holders? It is the court's duty to appoint someone to represent those people that you can't find. Because at some point, someone has to sign an affidavit saying, we have searched diligently for these people, and this is how we searched. List it out. This is everything that we did. And once you have that information, then the court is able to move forward. So probate may not be the answer this time. Quiet title may be the answer. 20 acres of land. Are there zoning issues related to the land? Are there any zoning issues? Are there any environmental constraints? Is it possible that they have some protected trees, some protected species? 20 acres is a pretty large area. And then, does the property have legal access? And just because it looks like it's on the public thoroughfare, it doesn't mean that it is, first of all, because it's possible that there's a tiny little strip that goes along in front of this property, and way down on the end where all of the trees are, that's where the access is to the 20 acres. And what people have done over the years is, this was the easy way, we'll just drive through here. And you begin to assume that you have an easement, when in fact you don't have an easement. So you need to be very careful. If you contact DSM, DSM's going to walk you through this and tell you what to be concerned about, what you can do, what you should not do, and what issues they find. Because again, once that property is divided, then it's divided. And you don't want them to give you 25 square feet that you can't even stand on, and everybody else get all of the property. You don't have access to your piece. So if you work with DSM, they will help you through that. The judge is not going to help you through that. That's not what his role is, okay? So you want to protect yourself. You don't want to end up with a deed to a piece of property that you can't use. And you can't say, well, the judge signed the order. It's not going to matter. So in this particular one, the person was trying to secure a mortgage. The first one, they were trying to get a loan to rehab. Let's look at C.
Wait, we didn't say whether it was yes or no.
Is it yes? Is it no? What is the answer?
Scenario C. In 1990, Jackie Jenkins received a 30-year mortgage to purchase a home in Tallahassee, Florida. Miss Jenkins had 2 daughters. One daughter has always lived in the home and cared for her mother. Ms. Jenkins died before the mortgage was satisfied. The daughter who lived with Ms. Jenkins continued to pay the mortgage and the taxes. Goal: that daughter now wishes to refinance the mortgage and make home repairs. Will the heirs fulfill their goals, yes or no? Hands for yes?
No.
Hands for no? Okay.
Okay. What is the asset this time? It's a house. And who is the record title holder? Why does the daughter think that she should be able to refinance? Because she cares for her mom, she paid the mortgage, she paid the taxes. Wrong. Okay. Okay. Now, the point of this particular one is that there are 2 daughters. One of the daughters has been there and would like to continue to be there. The other daughter is not there, and we're going to say the other daughter wants to sell this property. Okay. Now, what that means is that the daughters will probate the property. There will be an opportunity for them to receive this homestead, but after they receive it and both their names are on it, one of them is going to ask to partition the property, which means they want it divided, okay? Whenever you file a partition action, it's going to go through. So, in this instance, in order to become record title holders, the daughters are going to probate, they're going to receive the title to the property, and one is going to partition. Now, it is imperative that you understand that just because you live in the house, just because you farm the land, just because you pay the taxes, it doesn't mean that it's going to be yours exclusively. And I've been told that time is up.
So what you need to know is that it depends.
And let me just make another point. I want to make the point about DSM. DSM has regulations where they deal with heir property. There's special rules related to heir property. So you certainly want to make contact. You want to dial 850-606-1300. 850-606-1300. And you will speak to an advisor, and they will answer your questions and help you through your process.
What's the name of this now?
DSM.
It's development support and environmental management.
DESM, Development Support and Environmental Management. That's the department.
And if you'd like to speak to us further, we'll be back out at our table, so come by and see us again if you want to.